SJC-12618, Lynn Blanchard and others, v. Steward, Carney Hospital and others.
Mr. Drettler, good morning.
Good morning, Your Honor. May it please the court, Jeff Drettler for the appellant, Steward, Carney Hospital, and the other Steward entities, including Mr. William Walczak. This is the second time, as this court knows, that this case has come before the SJC in what I will refer to as Blanchard 1. In May of 2017, this court affirmed in part and vacated in part a lower court decision determining that an email that Mr. Walczak had sent to hospital employees describing the termination of employment of nurses and mental health counselors did not constitute protected petitioning activity. However, this court found that statements that Mr. Walczak made in the Boston Globe in a June 22nd, 2011, and related articles did constitute petitioning activity and therefore were protected under the anti-SLAPP statute. This court also found that the hospital had proven that the sole basis for the defamation claims against the Steward defendants were those petitioning activities stated in the Globe article. Under the existing paradigm at the time, Duracraft, that would have ended the analysis and the anti-SLAPP motion would have been allowed as to the Boston Globe portion of the defamation claim, which this court agreed could be split between the email and the Globe article because it could have been pleaded in two counts. However, this court established a new test, what it described as the augmented Duracraft test, which would give the appellee nurses a new opportunity to try and defeat the anti-SLAPP motion and remanded the case back to the Superior Court. The lower court ended up denying the motion on remand, and we have appealed again to this court, saying that there were two errors, that the lower court erred in abusing its discretion in not granting the Steward defendants' requests for limited discovery in aid of its anti-SLAPP motion, and that the lower court erred by committing a clear error of law in reaching its conclusion that the primary purpose that the nurses had filed the defamation claim was, in fact, to pursue damages for the defamation and not to interfere with the Steward's petitioning activity. The third issue, which I will address with permission at the end, is the issue raised by the nurses, which is whether or not this case is properly before the court on an interlocutory appeal, and whether it complies with the doctrine of present execution, which I suggest it does fall squarely within that. The test that this court established in Blanchard 1, the augmented Duracraft test, is that if the non-moving party, here the nurses, cannot make a showing that the petitioning activity lacked reasonable basis in fact or law, which the nurses concede they did not even attempt to make, that the non-moving party, here the nurses, could still keep the claim alive, and to make this showing, the non-moving party must establish such that the motion judge may conclude with fair assurance that the plaintiff's primary motivating goal in bringing their claims was not to interfere with and burden the Steward defendants' petitioning rights, but to seek damages for personal harm from the Steward defendants' alleged act. Therefore, it is the nurses' burden, this court put it on the nurses in this case, on remand to prove the motivating, what motivated them in filing the suit.
Let me ask you about the fair assurance issue. And it sounds like what you're arguing is that the judge has to say fair assurance in order to be assured that that's what the judge is looking at.
Well, Justice Budd, yes, the judge should say fair assurance because that's the only way we really know if the judge is applying the fair assurance standard. As raised in the nurse's brief and in the amicus brief, the point is made, and I think well made, that talismanic words are not necessary to be stated, and that if, in fact, that is the standard that was applied, then that should rule the day. And I would agree with that. I would assert, however, that one cannot tell from looking at this judge's decision whether that standard was applied or not. This judge, with all due respect to the lower court judge here, did not even mention the fair assurance standard in describing what the lower court's charge was. It's not even stated in his discussion of what is his role on remand. So it's hard to tell whether he applied it or not, and I would suggest that this court, in establishing the fair assurance standard, must have meant something by it. The fair assurance standard is not one that is seen frequently in civil cases. It's one that I was completely unaware of until I looked it up and found it in civil cases, and that it's used primarily to determine on appeal from a criminal conviction, whether or not, despite errors made at trial, that whether or not there should be a new trial, whether or not the appellate court can reach a determination with fair assurance that even had the error not been made, that the same result would have occurred. So I think there needs to be some evidence in the opinion that the judge applied that standard, and other lower court decisions since have actually used that standard.
No, it's fair. I get it when you use the words you know for sure, but can't we assume that if he listed all the things that he looked at and then said, I find that they did it not to chill the petitioning rights, then that's fair assurance?
I think that this court could. I don't think the fact that the words weren't mentioned precludes this court from making a determination that the fair assurance standard was met. However, I don't think, and as I will explain when I talk about why I think the judge made an error, the only error is not just that he didn't mention the fair assurance standard. I think that he didn't assess the issues appropriately either, which I will get to momentarily if I could.
Which you will. On the issue of discovery, you were asking basically for up to 2 hours for 9 nurses, so 18 hours of discovery?
Yes, Your Honor, and the nurses and the union have said that seems very excessive, 18 hours of discovery. However, I thought that was a pretty limited proposal to a shortened deposition. That's one short deposition, 2 hours. I mean, it takes a half an hour just in a deposition to talk about how you can take breaks and go to the bathroom and all that. So there's not a lot of substance left. We have 9 plaintiffs here. This is not a class action case.
So is it your view that it's always an abuse of discretion for a judge under the primary motivation standard that we've now employed to deny discovery?
Not always. In this case, however, there was no discovery earlier, and maybe in some cases they don't need to be. But I think that discovery, I have to fairly say, I think that discovery should be more liberally allowed now, given that the standard that this court has set is what is the motivating factor. We know from other employment cases determining intent and motive in cases, especially at the motion to dismiss stage, never mind at summary judgment or a trial, is very difficult. And we have the Supreme Court and this court has set tests for determining that, the McDonnell-Douglas burden shifting analysis, et cetera.
So go back to my question. Do you think, is it always an abuse of discretion for a judge to deny discovery of the plaintiffs to discover what their primary motivation is?
Not always, no, not always. And I
What
say,
makes this case one in which it is an abuse of discretion where it's not always required?
there was no evidence submitted by either party earlier that sufficiently, or on remand, that sufficiently addressed the issues such that discovery was not necessary, that the parties could submit evidence based on, interrogatories, document requests, if those avenues of discovery had been used earlier. But to have no discovery, yes, I think to just rest it on the complaint itself, I think, I can't say that in all cases, but I think in many cases, in fact, most cases, some discovery is necessary when you're talking about what is the primary motivating factor. To give some short examples.
Is your understanding, and unlike you, I wasn't here for Blanchard 1, but is your understanding that it's a subjective test, that we have to penetrate each plaintiff's sort of thought process? Is that what you take Blanchard 1 to mean?
Yes.
Yeah, so that we need to do like a McDonnell-Douglas analysis of racial prejudice or sexual discrimination. That's what we need to be doing, and therefore you need depositions to do that.
To some extent, yes. I'm not advocating that the McDonnell-Douglas standard be applied. I don't know exactly what standard should be applied, but this is a subjective test. What were each of these nurses, nine different people with 9 different motivations, what was in their mind when they decided?
So and back to the Chief's question, then interrogatories wouldn't suffice because interrogatories are usually drafted by lawyers, so you really need a chance of person-to-person exposure and questioning.
I think depositions are better. I think interrogatories would be a step better than we had. In this case, the nurses submitted evidence that they had suffered damages. I would suggest, however, that their evidence of damages should be disregarded because what they've cited to are interrogatory responses and documents produced in response to written discovery on the other 2 claims in this case, not the defamation claim. We had agreed among the parties to conduct limited written discovery on the 2 statutory retaliation claims that are also a part of this case.
I'm sympathetic to your point that we may have created this kind of subjective test, but when your name is thrown about in a negative way in the Boston Globe, isn't that enough to justify keeping that kind of claim alive? You've clearly had your reputation put into play, haven't you?
Well, I don't agree, and in fact, that gets to sort of the next part of the analysis, which I know I don't have much time left, as to whether or not the judge properly found that the claim was colorable and whether or not the judge properly concluded of what the primary motivation was. The Globe article, first of all, doesn't mention any nurse by name, yet he concludes without any evidence of his reasoning that it was of and concerning them. He concludes that he doesn't make any analysis of whether this is fact or opinion. He doesn't.
What's the statement in the Globe? Could you remind me what the statement is?
Sure. The statement in the Globe, there are several, but there is a statement that Mr. Walczak said he decided to fire the entire staff of the unit based on, I'm paraphrasing a little bit, and I'll quote, his decision was based on the investigation by former Attorney General Scott Harshbarger. The firm, Harshbarger, found that the 14-bed locked unit for extremely troubled teens was not functioning properly and advised him to hire new staff. The report indicated it wasn't a safe situation.
So, but why do you need, that clearly indicates all the nurses there, right, doesn't it? If you fire the entire staff, isn't that everybody?
Yes, that it wasn't a safe situation and that everyone there presumably played some role in it.
Now, our focus is at the time the complaint was filed, correct?
At the time the complaint was filed, and at the time the complaint was filed, we're focusing on, in looking at the motivation, I think we have to look at, okay, this court has said, let's look at, did they really do it to pursue damages? And I've outlined in my brief, and I won't have time now to go over it again, but these nurses have no, I would assert, no or very little damages, even if they prove their case, because they declined an unconditional offer of reinstatement during the pendency of the arbitration, before it was decided, and even after an arbitrator determined that there had been no just cause for the termination and ordered at least 5 of them who participated in the first part back to work, full reinstatement, back pay. They then entered into a settlement agreement. Of course, that settlement agreement was 2 months after.
Right.
But the unconditional offer.
Do you agree that at the time that they filed, they had prevailed in the arbitration, and you had 2 days earlier gone to federal court seeking an order to say it would be contrary to public policy for that award to be executed?
Yes.
So at the time they filed, they were faced with a federal lawsuit where you contend that they would not be entitled to any back pay or any of the award granted by the arbitrator.
Yes.
And so does that not permit an inference that at that time, faced with the prospect of you're bringing a federal lawsuit that would deny them any damages, that they could pursue a different theory of damages, that is defamation, in order to obtain damages arising from the conduct of Steward Carney?
Well, I argue, Your Honor, that they already are barred from virtually all damage for declining an unconditional offer of reinstatement that was made before the federal case was filed and before the arbitrator decided. And the union says, well, we don't speak for the nurses.
So you're saying that, I mean, your sister will point out that, will challenge that, I know, but putting that aside, can somebody not suffer damages arising from the view that they are a horrendous nurse who has allowed an unsafe condition to occur in their facility, even if they get their job back? Is there not the possibility of emotional distress damages or reputational damages?
Possibility, yes, but we're talking here about a lower court judge now charged with deciding what was the primary motivating factor, and it's not all or nothing. What were they really doing here, and how much damage really is there, given they already declined an unconditional offer of reinstatement?
And do you agree that in evaluating the judge's finding that their primary motivating factor was legitimate, that that's an abuse of discretion standard as well?
I'm sorry, could you repeat that?
You agree that in our review of whether the judge was correct in finding that their primary motivation was legitimate, that we review it for abuse of discretion?
Yes, abuse of discretion or clear error of law, and it's all wrapped into, whether he found with fair assurance. Yes.
Which goes back to Justice Budd's earlier question.
Correct.
All right, thank you.
Thank you.
Ms. Radowski, good afternoon, I'm sorry to say.
Good afternoon, thank you. Your Honors, may it please the Court, my name is Dahlia Rudovsky, and with me is Ellen Messing. We represent the nurses who are in the gallery. I do want to reach the question of whether this appeal is proper, but before doing so, I do think it's important that the court understand that there was voluminous discovery and a very voluminous record was presented on remand to the trial judge. That included interrogatory answers as to damages, which were common to all the claims in the case. It included W-2 forms. It included some of the interrogatory questions had to do with earnings and mitigation, failed job searches, emotional distress, and so on. We also presented the verbatim interview notes that the hospital's investigators took about the incidents in the unit, and these were presented to show cooperation by the nurses in the effort to keep the hospital open, the unit open, and to improve the unit. So we say that the judge was operating from quite a fulsome record when he considered the issues on remand. If I may
But
pivot.
is your understanding it's a subjective test that you would have to analyze each plaintiff's personal motivation for
I
why
think-
they brought the suit?
I'm glad you brought that up. I think a subjective test would be highly improper because.
So what did we mean by primary
So an
motive?
objective test would be such matters as, for example, if the burden is on the plaintiffs, but, I'm sorry, the non-moving party, the steward here could have gone another way. They could have, if such evidence existed, they could have said, well, look, here's letters that the nurses wrote to the Boston Globe, wanting to close down the unit. Here's a publicity campaign they conducted. Here's evidence that.
Isn't the best evidence talking to the plaintiffs? I mean, we normally get to depose people who are suing us, don't we?
I would say that is not true just to give your honor.
I mean, you're an experienced employment litigator. How many times have you had cases where they don't get to depose your client?
Depositions are important for impeaching other statements that might be in the,
We're
other-
trying
in
to
the
get into
pleadings or
we're
in
trying
the-
to get into the heads of the people, right?
yeah, but I think it's almost black letter law that trying to get in the head, even on a summary judgment motion, is highly disfavored. What we try to use when I bring a case,
Even, again, I wasn't here for Blanchard 1, so the language we're interpreting is the primary motivation for, right?
yes,
And that
And-
to you is, educate me. So how do you do that without?
I'm doing this by analogy to discrimination cases.
Right.
The best evidence is not what someone says about, gee, I was biased. It's what they did. So the same thing would be true here. What did the nurses do? What could Stewart point to? And if they, for example, had
But
conducted.
let me just push you back, and then I'll stop interrupting. Normally, in an employment case, you have a whole a long-term relationship with a supervisor and an employee. So you've got a lot of evidence about what's in the thought process of that supervisor. Here, we're looking at a motivation for bringing a lawsuit, right? Not whether the supervisor is discriminatory or not. It seems like a more complicated
Right.
inquiry.
So here, for example, the nurses showed, and we proved to the court through W-2s, sworn affidavits, that there was over $1 million in lost income collectively, over $1.5 million, as of the time the suit was filed. Certainly, that is objective evidence of damages which the nurses claim resulted directly from being defamed. They couldn't find jobs. That's objective evidence, and they would say the same thing.
So the evidence that they're looking for damages is the evidence that their primary motivation is not to interfere with petitioning activity, but to get compensated.
Yes, the evidence that damages exist, not just they're looking for it, but it exists and it can be demonstrated.
So just help me. You say it's not a subjective test, meaning that we don't need to look at what the intent was of the plaintiffs? Or are you saying that we can determine their intent through inferences from objective evidence?
The latter.
The latter. So it is,
Yes.
we do need to ascertain what the intent was of these plaintiffs.
Yes,
But you're saying we don't need necessarily to speak to them, we can infer their intent.
right. Their intent as demonstrated by their actions. And as I was saying, if there were some evidence out there that they had engaged in anti-petitioning activity, that would be enlightening as to their intent, but there was nothing of the sort here. That's why Stewart felt compelled to ask for depositions.
So am I correct that it's not your position that it would be abuse of discretion if the judge had allowed the motion?
I don't think it would be abuse of discretion, but it certainly was not abuse of discretion to deny the motion for deposition.
And why in these circumstances was it not an abuse?
Because the sort of default position is that discovery is not permitted on SLAP motions, and that the person seeking, the party seeking discovery has to make a showing, and it is within the discretion of the trial court to determine whether what the trial court has is enough to make a determination without that discovery. And the judge here had a thick appendix to each brief with interrogatory answers sworn, documents, transcripts of interviews, and so on.
And what would be the next step after the denial of the motion to dismiss? And the denial of this discovery? What's the next step in this case?
The next step is we go into more fulsome discovery, and we would in fact have full depositions and
So
other-
in those circumstances, would the subject matter that the hospital wants to investigate, would they be allowed to do that then?
Of course. They would be asking, what were your damages? What was your emotional distress? Tell us about it. They would be asking, as they say in their brief, who thought less of you? What comments did people say to you that show that your reputation was hurt?
Would they ask about motive? Would that be
I think
permissible?
at that point, the motive issue drops out of the case.
They would not be allowed to ask that.
I think it would be irrelevant. It wouldn't be an improper question. I mean, it's not,
I'm thinking,
it's not a
well,
matter of privilege.
it might ultimately later, if there's a final appeal.
I don't think that, I think once you're done with the SLAP inquiry, you're done. Because the whole point of a SLAP inquiry is that you don't try the case on that
Right.
particular matter, and the case would have gone forward. However, Steward would retain all its appellate rights on all the things that they're pointing to here, whether the defamation was of and concerning the plaintiffs, whether the statements were true, whether they were privileged, all those standard defenses, which are what they're relying on here, are available on appeal on the merits. Similarly, their challenge to the damages are all their challenges to the actual damages. Did you suffer damage?
That doesn't really add anything to the argument, because the whole point of the anti-SLAP is if it's based on petitioning activity to resolve the case early.
Exactly. But the augmented test puts that aside as the ultimate question and raises another question as to motivation. And once you get to that second, the augmented Duracraft test, you're in a different
But
ballpark.
it does seem to me that the augmented test, you are getting to the state of mind. I appreciate your point that you're getting to the content of the consciousness based on not just what the nurses might say in a deposition, but everything that's part of the record, including the damages that would actually exist. But I go back to Justice Kafka's line of questioning. Don't we need to have at least some discovery to understand?
There is sufficient discovery in the papers, and if the rule was there has to be some discovery, that would turn on its head the normal state of affairs, and that's not what this court said was necessary.
But doesn't this test has added a new, just what you said, it's added a new dimension to SLAP. And this is the only opportunity the defense has to not have you in between them and the plaintiffs, right? All that other discovery comes through the lawyers, right?
Well, I would say that W-2 forms do not go through the
Well,
lawyers.
but the W-2 forms are just what they earned, which...
Right, showing real damage. If there are real damages in the millions of dollars, that would suggest that someone who believes they were defamed and therefore could not find work
Right.
had real damages and were motivated to correct those damages.
Right. Although, back to the chief's question for a second. So let me change it again. So we didn't have them challenging the arbitration award, and you just had this unconditional offer of reinstatement and back pay and everything. By the way, did it include back pay and this unconditional? So they offer back pay.
There was not.
Bear with me for a second. I'm just posing the hypothetical first. So they offer an unconditional reinstatement and back pay. The W-2 forms in that case, don't add anything, right?
If they were reinstated and had their jobs back and full back pay for the time of unemployment, and then moving forward, would they have a defamation claim? They would have a claim, but it would be a lot less strong.
Right, so in that case, then, depositions may be necessary, but not in this case? Is that what you're saying? Because he was challenging the arbitration award itself?
I would have to think that through, but it's counterfactual. I mean, we had nurses facing years of unemployment, no job,
Right.
having their names defamed broadly throughout the whole range of the Boston Globe's
Oh,
publication.
and I get there may be a whole separate emotional damages component to having your name in the Globe accused of, so I get that, but I just find his job is real difficult if he doesn't get to talk to any plaintiffs. And the burden of proof is on him, right? Or is the burden of proof in this new Duracraft test is on who?
The burden is on the non-moving party to show what their motivation was. So
Okay.
in your
So it would be you. It would be you.
counterfactual example, where the hard damages are absent, perhaps the subjective motivation would be more pertinent to the judge's decision-making.
Mm-hmm.
But that's not our case. Our case is there's no evidence of anti-petitioning activity at all in any form, period.
Should we leave it up to the judge to decide what the judge wants as far as information on motivation?
Yes.
That's the abuse of discretion
That,
standard.
that is the standard. It's left to the discretion of the trial judge whether depositions are necessary, but they are not automatic, and they're not even, I don't think it's 50-50. There has to be a showing made for the depositions. I want to,
Oh, go ahead. I was going to ask you about the colorable. So just, are you using a 12B6 standard there, or are you using something different?
I think that's the 12B6 standard,
Okay.
yes. Now, if I may, I think there's a preliminary issue that is really dispositive of this case, and that is the doctrine of present execution. 40 years of this court's precedent says that an appeal is improper if it overlaps with the merits of the underlying claim. An appeal is proper if it raises a collateral issue, as the first appeal in this case did. And I'll give you the cases that, we didn't put them in our brief, so I'll tell you now. The standard was announced in Borman versus Borman, a 1979 case. It was articulated best in Maddox versus Ricker, a 1988 case. And in that case...
But I'm confused, though. Anti-SLAPP, I know those old cases, but anti-SLAPP is a classic case of present execution, isn't it?
The SLAPP, under the prior Duracraft standard, SLAPP cases fell within the
So
exception.
your view is now, your view is now we've taken that out with the new enhanced Duracraft?
I'm saying that in the case of the augmented Duracraft standard, if what the moving party does is talk about the merits of the underlying claim, as Steward has done here, then it takes it out of the exception, because it overlaps completely with defenses that could be made on the merits after a full trial or at summary judgment.
So whenever we get to the third prong of Duracraft, there's no present execution ever?
I won't say whenever. As I said before, if there was...
Isn't this a three-part test that we're going to apply in every single case now? So
Not
are you?
necessarily. If there was evidence, as I said, that the nurses went out and organized the public to close the unit down, that would not be duplicative of their defamation claim. That would be evidence independent and collateral to the defamation claim of anti-petitioning motivation. So in every case, you won't need it. But in this case, and in cases like it, where Steward is relying on an examination and a challenge to the damages, it's looking at whether it's arguing the article was not concerning the nurses, the article was true, the article was privileged,
So,
all those...
but let me just,
You don't see
and-
this as sui generis? You don't see this case as sui generis?
Well, in a sense they are. We're the first
I mean,
one.
look how long it's taken to get to this point. This is not the ideal.
Certainly not. Certainly not. In the next case, the dual second
Well, that was another
prong.
one. The
Pardon me?
next one is another one of these cases that is just lingering on.
Uh-huh. Well, perhaps because this was a new
Yes, I understand.
standard.
I understand that. That's why I'm saying maybe they're sui generis.
But in the next round, the inquiry has to be whether the appeal from the order is an appeal on the merits of the claim. Because if it's on the merits, it does not fit the doctrine of present execution. That's a very narrow exception, and what Steward is essentially asking this court to do is to set all that aside, all that law aside. We've had 40 years of understanding of what that doctrine means, and to say in the SLAP context, we're throwing that out, and I would suggest that doing so upsets the very careful balance that this court created in the Blanchard 1 augmented standard. It's very important to remember that the plaintiffs here also have constitutional rights, and their constitutional right is to take their, to challenge the defamation that has ruined their careers in many cases, and that has caused them great suffering. And here they are, 5 years in, thousands of pages of depositions, and we're still not anywhere near trial on the merits.
All right, thank you.